Hello world, welcome to my channel, Proteus Augustus. I'm an artist, scientist, and American constitutionist. Today is May 11th, 2020. Before you watch this video, I recommend that you see my video titled Lawyer Wars, because this video is a continuation of that line of logic, and I want to prevent redundancies. The other thing I'd like to say before I get into this video is that human beings haven't changed really that much in 30,000 years. These types of conflicts have happened throughout human history. The difference today is what society you're in and what court venue and body of law is used to seek justice in certain matters and controversies. As an American constitutionist, I have to look to our body of law. Now, it's been my practice in the past to start from the Supreme Court of the United States, seeing as how all states are supposed to follow their judgments. Unfortunately, a lot of state actors like to focus more on their state law and start from that position, which in many cases are contrary to standing opinions of the Supreme Court of the United States. And the reason they stand, as I said in my first Lawyer Wars video, is that the Supreme Court of the United States simply cannot take every case and controversy, even if they're wrong. They have to rely on other litigators and justices or judges, as it were, to apply the craft as it has evolved. And it's been my personal experience to see that in many instances is not the case. I mean, if you look at what happened to General Flynn, this is not new. This is standard operating procedure, and prosecutors' offices all throughout the land and in every state. It just goes to show you how protected a lot of these people in the media and in higher stations of our society have been blind to these things, or in many cases have used the system to get an outcome that they wanted. It took this egregious act by the Justice Department and the FBI, not to mention the Whitey Bulger case, but that's a whole other story, for people to really realize what's going on here. And in this Arbery case, it's no different. Okay? Now, I'm of the view that the whole purpose of a trial, and perhaps this should have went to trial from the beginning, is to lay out the facts as they are and have a jury of peers to decide the matter. Now, this case has been around a while, and there are public records and opinions on previous prosecutors and the police, and there's also a video, so there's a lot to work with here. And my position today is a preliminary one, and I by no means are going to say whether one person is guilty or the other. Okay? But given all the facts, which I don't really need to get into, because in my opinion it boils down to the video and witness reports. And so I will focus these two cases to highlight what the important issue is in this case. The U.S. Supreme Court of the United States has dealt with these matters ever since the existence of our jurisprudence. And indeed, humanity is not, should I say, ignorant of these kinds of controversies. I mean, men have fought over things, over women, you name it, money, and a lot of times it results in assaults, batteries, and murders. So, in this case, the law has been established a long time ago. Now, before I get into the case law, let me say one more thing without trying to bounce around too much, is that anybody that's taken an LSAT, which is the graduate exam to try to get into law school, knows that it's basically an IQ test, as it were. I mean, the people who take a test like that have a requisite intellect to be able to go through all the ruminations of these different mind twists and literary problems, to score well on the test if they choose to do so. However, that test does not evaluate a person's moral component, their incentive for wanting to be a lawyer, or how they're going to practice law in the future. And that's why we also have lawyer wars with respect to morality. It's unfortunate that a lot of lawyers and talking heads want to get on TV and do all this race baiting. And that has, pretty much existed for, since the country began. But in our day of in the information age that we're in today, the average person has access to a lot of information, and a lot of them think that they know better. Okay? And they don't. All right? Now, there's this concept called mens rea that a lot of these talking heads and lawyers, they get on TV and say, oh, well, this guy was thinking that, this guy was thinking that, and if it was me, I would do this or I would do that. That's irrelevant. Mens rea just means what is in the person's mind. The people in the controversy, what are they thinking? That's what a trial is for. No lawyer has the right to assume that they know what a person is thinking. Okay? Now, they may take the circumstances of the event, the evidence of what was said, things of that nature to purport to the jury why they think that this person committed an act. Okay? Now, I believe that a lot of lawyers do that because a lot of lawyers, especially prosecutors, are looking to taint the jury pool, because in the end, a lot of these lawyers want to be the governor, okay, or they want to go to Congress. And in order to do that, they have to get votes. So in their mind, they really don't care about the law, okay? They're not really students of the law. They're just using the law as a tool to get an outcome for themselves in the future. Now, that being said, in these cases that I'm going to cite, I am going to omit the race of the persons, the age of the persons. Really, it doesn't really matter. Okay, the law is not supposed to be skewed towards someone they think is a better person or isn't a better person. I mean, in criminal law, just because someone had committed a crime in the past does not necessarily mean they committed the crime at issue. That's up for the judge to determine whether it is a pattern of behavior or not, and that's a whole nother body of case law. But anyways, let me get to the point. So what we have in this Arbery case, okay, as it boils down to, is a struggle over a weapon. Now, you can think that Arbery was casing the joint. You could think that those guys that went out there with the shotgun were racist. You can think whatever you want. What I'm telling you is, according to the law as handed down by the United States Supreme Court, okay, is that those are all irrelevant. It's just simply irrelevant. Now, let me get into the first case. All right, now in this first case, and like I said, these are older cases, but this is standing law. Stand your ground is not something that is just been invented by some states, okay? Self-defense wasn't just invented, and then, hate crimes, those are crimes of thought. Again, in my opinion, those are unconstitutional. If you kill a guy because you're a hitman and you want to make money, or you kill some girl's boyfriend, it's still a murder. Okay? You can give the jury a reason why they did it, but the fact remains, did that man use his hand to kill another man? And was it legit or not? That's all it boils down to, people. That's all it boils down to. So in this first case, this is Thompson v. U.S. 155 U.S. 271. And this was brought up by the 1-5 Superior Court, I believe, that at 73. I believe that's the Superior Court case that was brought up to the Supreme Court. Now, what this case was about was some individuals, two groups of individuals, okay? And back in those days, there was no limitation on age with respect to weapons because, people had to go hunting. It was a way of life, to put food on the table and whatnot, right? We're talking Wild West action here, okay? So what happens is you got one group of people, one group of men, let's say, or actually in this instance, I know I wasn't going to say age, but let's say these were juveniles, okay, under the age of 21. And one group was taunting this individual of another group on previous occasions, saying derogatory things, throwing rocks at him and whatnot, right? So the person that experienced these harassments and assaults decided to arm himself. And on the day of the controversy in question, he was performing duties on a farm, and the individuals who had harassed and threatened him before happened upon that area. Now, this case came up on a jury instruction to the lower courts for a retrial. So the opinion didn't decide whether this man lawfully shot the person or not. The jury instruction was basically that the jury could only consider manslaughter or murder based on, certain facts that were reported and that were in dispute by various witnesses exactly what happened. And I'll leave that to you if you're studious enough to call up this case and read the details for yourself. In any event, an altercation occurred. And there was a struggle for a weapon. Okay? And the person who had the weapon, it exchanged hands, and then he recovered the weapon and shot and killed one of the other persons. Now, the question in that case is whether the jury had the right to review if he had a self-defense claim, which was not put before them. The lower court judge basically gave him the option of manslaughter or murder, saying that, hey, this guy had he armed himself, okay? He knew that people were threatening him, and that, given the circumstances, it's probably more manslaughter. So it comes down to, because the man was armed, does that necessarily mean he had the intent to kill anyone? Okay? Which is somewhat related to the Arbery case. Now, these guys have a right to carry a weapon. Why are they carrying a weapon? For self-defense. It doesn't matter if they know what's in the mind of Arbery or any other person. If you have a right to carry a weapon and you're walking down the street, there's a reason for that. Okay, so all of the other facts don't matter. Okay, what matters is what happened during the struggle. Okay, Arbery closed distance on that man with the shotgun. All right, now I don't think it's fair to say that they were hunting him down like these talking heads or these race baiters are saying. Listen, if they wanted to kill the guy, they would never even let him get close to the gun. He would have just dropped him right there. Okay? Well, what happens is, instead of Arbery deciding to avoid the situation, he has the right to stand his ground, but he doesn't have the right to go after the weapon. Okay? Once he put his hands on that weapon, they were both in a struggle, a life or death struggle. The person who had the weapon didn't bring it with the intent to kill. He brought it with the intent to defend himself. And right now there's no evidence that even if he brandished the weapon, even if he threatened to shoot the guy or whatever, right? We don't know that. But the video is very clear. Arbery closed distance, grabbed the weapon and fought for it. And the only intent that would be reasonable for him to do that is to take the weapon from him and to turn it on the other party. So anyways, in this Thompson v. U.S. 155 U.S. 271, the Supreme Court of the United States says no. Just because that man was armed does not mean he had the intent to kill anyone. And that the jury has the right to look at whether there was a self-defense issue or not. And that's where the conflicting testimony comes in. One group says, hey, we're on the other side of the fence. He comes over the fence, punches me in the face while he's got the weapon in the other hand. And then they struggled. The other party says, no, they're on their side of the fence doing their chores. And the bullies that were bullying them on previous occasions came over with sticks and clubs and whatnot. And he didn't fire until they had jumped on top of him and he pulled his weapon out to defend himself. That's what the trials are for. Who are they going to believe? In the lower court, the judge says to the jury that clubs and sticks aren't weapons. That they're not deadly weapons, let's call it. Supreme Court rejected that. Once you're in a fray, I could use an ashtray, okay? There's people who are skilled and that can use just about anything, okay? It's not intended to be a weapon, but once you use it as a weapon, it becomes a weapon. So that's another reason why the court said, no, you can't tell the jury that he wasn't in threat for his life just because the other people didn't have a firearm. Now, that's where that case is. I'll leave it up to you to look at the particulars. But the bottom line is, there was a struggle for a weapon. Both people are struggling for their life at that point. The only question in that case that, to me, was the firearm discharged during the struggle? And after the struggle, was the firearm discharged again? And that works our way into the next case. The next case is called Roe v. U.S. number 439. Again, Wild West. I'm going to leave the parties, race or whatever out of it. Because unfortunately, a lot of people, like I make comments on other YouTube channels. Oh, well, if it was a black or a white and they did this. No, that's not how I think. I've never thought that way. I'm a fair and honest, regardless of the controversies I've been in. The reason why I'm standing here today a free man is because I was in the right. And I knew how to prove that. Okay, and this is one case I argued in brief, without getting into more detail. Again, that case is Roe v. U.S. number 439. Now, in this case, we have two adults in a bar. And they're having supper, or dinner, however you want to call it. They're eating. And one person's got an issue with the other person. Okay? A few jibes going back and forth. Again, all of that is irrelevant. Right? And that's why, again, I have to say that hate crime statutes attack mens rea or words that are said, what is commonly referred to as fighting words. In my opinion, I go by sticks and stones break your bones, names never hurt you. That's just my position. Okay? Now, in this case, like I said, they were both in an establishment, eating, drinking. Witnesses said that neither of the parties were drunk or substantially inebriated. It was just a matter of animosity towards one another. Now, one man's trying to get the goat or his ayah going. The guy's ignoring him. Okay? So what happens is the other guy kicks the chair and hits him in the leg a little bit, right? While he said a derogatory remark as he was passing by the person. Now, he goes up to the bar and he's standing at the bar. So the person that was sitting in the chair decides that he's going to get up, pull his knife, and lacerate the man's face. After which, the man pulled out his weapon and shot him and killed him. Of course, that case made it all the way up to the Supreme Court of the United States. Okay? And it all turns on when a person recovers their right to self-defense. Okay? Now, what the court ruled in that case is that even though the person who, let's say, instigated an argument with fighting words or whatnot, okay? Once he, let's say, retreated from the situation somewhat, he goes to the bar and he recovers his self-defense. All right? The man doesn't have now the right to say, well, he kicked me in the foot, therefore I'm going to stab him. Okay? Now, if they were in the struggle, in the moment of the struggle, that's a different situation. But what the Supreme Court said was the man recovered his right to self-defense because he retreated a distance from the person and was no longer a threat to the person while standing at the bar. Now, in those days, no one's going to bring an assault charge against something like that. You know, I mean, these days in the court, if you touch someone without their consent, that's an assault. I mean, it's, you know, really? But anyways, and, you know, if that was the case back then the guy had redress. He could go to the court and say, hey, the guy kicked my chair. Right now, he's using bad derogatory terms towards me. Right? Blah, blah, blah. Right? He doesn't have the right to then get up, close distance on the other man at the bar, wielding a weapon, and stabbing him, and then claiming that it was justified stabbing. Does that make sense to you? So, in the Arbery case, even if something was said to Arbery, okay, stop, we want to talk to you. First of all, Arbery could have kept going, all right? We only give the privilege of forcible arrest to law enforcement because they have to demonstrate a constitutional right to use force against a person. But that doesn't mean a regular citizen does not have all the other rights a police officer has. It's just one thing, and that's forcible arrest. He can follow the guy until the cops get there so he can ID him. Even if he wasn't the perpetrator of some crime, it's irrelevant. That's all hindsight. Okay? Again, it doesn't matter what the guy with a shotgun had in his mind when he got out of the truck. Okay? There was distance. Okay? Now, a crime hasn't been committed yet. If the guy took the shotgun and killed him, that's pretty clear cut, people, right? But standing there having the right to carry a firearm for self-defense purposes, having the right to open carry, okay, is not a crime. Okay? Again, Arbery closed distance on the man with a shotgun, and they struggled for the weapon. That is all that matters here, people. It doesn't matter what was in Arbery's mind, the other guy's mind. It doesn't matter. All of these things leading up to why they went after him. Hey, if they were harassing him and there's a harassment statute in that state, then he could have waited till the cops got there and said, hey, these people are fucking stalking me. You know? And then, you know, turn the tables on the guy with a shot. He did not choose to do that. He chose to close distance and go after the weapon. So at that point, you got, like I said previously, you got two parties fighting over the weapon. Right? So in this case, Roe v. U.S., it says that guy with the weapon has the right to defend himself. Now, of course, in Roe, the guy had a knife and he cut him in the face. Does it have to go that far? In my opinion, no. Because once he puts his hands on that weapon, they're both in the possession of the weapon. One man had the legal right to possess the weapon. The other person did not. Again, beside the point. They both had their hands on the weapon. Now they're in the struggle for their life. And that's where the video comes in. And as in the Thompson case, what this is going to boil down to, in my opinion, putting aside all the race baiting, all the rhetoric, and you know, the prosecutor that wants to use this to upset the populace so that he can make himself or herself look grandiose or whatever the case may be. It only comes down to that struggle. And whether the firearm went off during the struggle, when there was combat, mutual combat for the weapon, or whether once Arbery retreated, or did he fire again? Now, if he fired again once Arbery retreated, that's a different story, and that's what isn't clear right now. Okay, again, doesn't matter what they thought Arbery did. It doesn't matter what people think of that man with the shotgun. It only comes down to the struggle, people. It comes down to that act. Okay? That's all it's going to come down to, in my opinion. So, tell me what you think. I'm willing to debate anybody on this, a member of the bar or otherwise, and where I can get into more of the details. But I have to leave it to you to see if you want to look up these cases and evaluate them for yourself so that you can better understand what the law really means. Until then, think free and be free.